Any mention for unlisted matter?
Oh, yes, my lord. May I please, your lordship? My lord, I may kindly be permitted to move an unlisted motion. My lord, we filed it yesterday. This is a Manipur matter, my lord. The same matter which your lordship last time ordered, my lord. Your lordship ordered the restoration of the governing body. They passed the order of first stage, your lordship already examined. Thereafter, my lord, they did not restore it even for a single day, and rather they issued an order declaring the governing body as null and void. So, my lord.
Where have you served the other side?
No, this is a contempt petition, my lord. We do not serve. Contempt petition, we don't serve, my lord, other side.
Contempt?
Yes, my lord.
Very well.
Division-based matter, my lord. Can it be taken up during the course of the day, my lord?
It will be taken up immediately. Get the
Highly obliged.
take it up.
Highly obliged.
At the end of the vote.
Highly obliged, my lord.
From supplementary list, item number 1.
May I please, sir. Well, this is an appeal against order dated 22nd of August 2023, my lord. In fact, my lord, the appellant has filed a writ petition seeking direction from this honorable court to the police, my lord, who has not registered case on the basis of FIR filed by the petitioner, appellant, my lord. And my lord, police has stated, intimated the police petition appellant, my lord, that on his FIR, my lord, it is the returning officer who can take action, my lord. So that's why my lord, the appellant has also approached my lord, the Election Commission of India. But the Election Commission of India has also not taken any action, my lord. So that's why the appellant approached.
Who is the appellant? Appellant was a candidate.
No, my lord, he is a voter, my lord.
He is a voter.
Voter.
What complaint had he filed?
He filed my lord, complaint that the respondent number 7, my lord, during his election campaign, he has, my lord, manipulated religious.
What is your locus standi? What is your locus standi? He has manipulated. The candidate who has won or the candidate who has lost will complain. You have no locus standi.
But my lord, any person.
Nothing. A busybody. Nothing. No locus standi. Let us see what the trial court single judge has said.
My lord, page start from page 143, my lord. And the relevant page, my lord, 151, paragraph 11, my lord.
329 is a bar. 329 of the Constitution, where the Election Commission takes over control of the governance.
My lord,
This is a
para 11, my lord. Page 151.
yes. Yes, very good. Well done.
My lord. May I read, my lord?
We've seen it. Do you have anything else to say?
My lord, in my emulsion,
Haven't you learnt your lesson from the trial court order?
my lord, but in my emulsion, bar of 329B, my lord, only in respect, my lord, if I challenge the election can.
What is your prayer?
My prayer is, my lord, only to direct the police authority to register a case and investigate.
And what will the prayer do?
They say, my lord,
Where is your prayer? Where is your prayer?
my lord. Page 34, my lord.
Yes. No. It's in effect to unseat him, which you cannot do. The appellant should have learnt a lesson from the order impugned, by which his petition as a busybody under Article 226 of the Constitution to, in effect, unseat an elected representative was dismissed with cost of rupees 15,000. Full stop. Paragraph. The prayers in the petition are set out. Full stop. It is evident that where is your FIR? 3rd of April. Where is your FIR?
Just a minute. My lord, page 58. Page 58, my lord.
58. Set up the prayers from page 34, 35. Then the entirety of the writ petition is founded on the perceived inaction of the police authorities in Williamnagar to take action on the basis of a complaint lodged by the appellant herein on 3rd April 2023. Full stop. The police complaint was preceded by a complaint filed before the Chief Election Commission of India on March 23, 2023. Full stop. It is evident from the 3rd paragraph of the police complaint of April 3, 2023 that the purpose of the petitioner's enterprise was, open quote, to declare the election of Mr. Marquis N. Marak to be void for adopting corrupt practices and holding fresh election. Full stop, close quote. The previous paragraph, the previous complaint to the Election Commission and the subsequent petition in this court are for the same purpose. Now, were for the same purpose. Full stop. Quite plainly, the appellant herein had no locus standi to complain of, to seek the election of the relevant, of the successful candidate to be annulled, since the appellant was not a candidate and cannot be said to have been directly affected by anything that the appellant may have complained of. Full stop. Paragraph. By the order impugned, dated August 22, 2023, the writ court referred to the provisions of the Constitution and the Representation of People Act 1951, together with the Conduct of Election Rules 1961, to hold that the petitioner had no right to have the election of the successful candidate cancelled or annulled, and even the police authorities could take no steps in such regard, since the only authority in such regard would be the Election Commission. Full stop. Further, the writ court, quite appropriately, held that once a candidate had been declared elected, it was only by way of an election petition that the result could be annulled, full stop. Since the appellant herein could not have filed an election petition, and the failed candidates, who were directly affected by the result of the election, did not lodge any complaint or file any election petition, the entire exercise by the appellant herein was a farce. Full stop. Paragraph. There is no room for interference with the reasons indicated in the judgment and order impugned. Full stop. Paragraph. Accordingly, WA number 33 of 2023 is dismissed with further costs of rupees 15,000, which should be paid to the State Legal Services, Meghalaya State Legal Services Authority within 4 weeks from date. Is there any interim application dismissed?
My Lord, Lordship may, my Lord, has rightly passed the order, but my Lord, the allegation containing that, my Lord, complaint petition, this FIR, well, they also constitute offence, they are also punishable under section 153A, 163, 17. So, my Lord, the police may not have registered.
Thank you. We passed
My
the
Lord,
order.
only one fact, my Lord.
There's something.
He in fact filed an election petition, my Lord, belated, my Lord, so he had to withdraw that, my Lord. EP number 8 of 2023, my Lord.
Oh, after this order is passed, it is submitted on behalf of the Election Commission of India.
That's reflected in the order also.
That belated election petition was filed by this appellant, which was subsequently withdrawn. Full stop. Just record that. Thank you. Yes.
From the minutes, item number 1.
Please don't make elections a farce. Please. It's a very, very sacred thing. Please don't. If you have good grounds, definitely, but otherwise don't reduce it to a farce. As lawyers, you have that responsibility.
No, but my Lord,
Whatever complaint you have. Yes.
I think private respondent have received a copy. I think my learned senior is appearing on behalf of the private respondent.
You are appearing for the private respondent, sir?
Yes, my Lord.
Yes. What is the matter about?
Your Lordship, since today I didn't prepare, Your Lordship, only give me some time. I will prepare
Very
the
well.
next date.
Since the appellant seeks an accommodation, we'll adjourn it for 2 weeks.
Lordship.
Let the matter appear a fortnight hence.
Lordship. Much blessed, Lordship.
Item number 2.
Lord, Mr. Pathak from Guwahati is appearing for the respondent. He informed me that he will not be available today, he is traveling.
What is the matter?
My Lord, here, my Lord, there are two aspects of the matter, my Lord. This is regarding
Very well, since the respondents are not represented, let the matter stand over for a fortnight. The appellant should inform the respondents of the adjourned date.
I'll inform the council, my Lord.
Yes,
Item number 3.
but do it formally.
My Lord.
May it please your Lordship.
Yes.
My Lord, before I take your Lordship to the appeal, my Lord, there is an application for condoning a delay of 5 days.
That's all right. Tell us the merits of the matter.
Yes, my Lord. So, my Lord, should I press upon the IA or I should proceed with the appeal, my Lord?
Merits.
Okay, my Lord, on the merits, my Lord. I'm obliged, my Lord. My Lord, the appellant before my Lords is currently serving as an associate professor, my Lord, in the Department of Biomedical Engineering in Nehu, my Lord, University. Now, my Lord, what happened? This appellant was appointed in the year 2013, my Lord. There are some dates, my Lord. I would just like to take your Lordship to a little background of the case, my Lord. Now in
No,
2013,
just give us a brief summary of what your grievance is and
Yes,
the grounds,
Yes,
and then you take us through the papers.
my lord, the basic contention is, my lord, when he became eligible in the year 2016 for promotion, and as per the UGC regulation, my lord, there is a need and mandate under the law that the authorities would now proceed to initiate the, my lord, departmental promotion DPC in respect of the candidates who becomes eligible, my lord. So the mandate says that within a 6-month period, they need to hold a DPC, my lord. Now the problem which arose in the current case was that for almost a period of 2 years, they did not hold any DPC. In 2018, there was a complaint which was lodged against the appellant before the, my lord, CBI regarding some misappropriation, and also another case came up in 2021, my lord. So finally, my
No,
lord,
sir, if you are trying to say
my lord,
that if the DPC had been held earlier, this incident would have been irrelevant,
My lord.
that is not the law.
My lord.
The law is when the DPC sits, whether it sits late or not,
my lord,
when the DPC sits,
My lord.
if there is departmental proceeding against you,
Yes, my lord.
if there is a sealed cover procedure,
Yes, my
then
lord.
that sealed cover procedure will follow.
Follow, my lord.
And if you are ultimately acquitted of the charges in the disciplinary proceedings,
My lord.
then you will be given effect from the date that you were entitled to.
My lord.
And the date that you were entitled to will never precede the DPC.
my lord,
It will always be on or after the DPC.
my lord. My lord, I do appreciate, my lord, what has fallen for my lords, my lord, but our humble submission is, my lord, that since, my lord, the DPC was conducted in the year 2023, and what we could, my lord, understand from the bare reading of the 1992 provision, my lord, where it says, paragraph number 2(3), that, my lord, at the time of consideration of the case, which your lordship has just pointed out, that if you have these 3 conditions existing, these 3 conditions, if you fall, then your case would be put under seal cover, my lord. My lord, in this regard, my only respectful submission is that, my lord, now these authorities, my lord, have to assess the merits of a candidate based on, my lord, the requirement and mandate which says that there has to be an ACR or an API, which is Academic Performance Index, will have to be taken into note while they are examining the candidates during the DPC. Now, this ACR,
Let us not be so theoretical.
my lord,
Let us look at the practical side of it.
yes, my lord,
Let us say for 4 years,
yes, my lord,
during which I should have been considered for promotion,
Yes, my lord.
my performance has been excellent.
yes, my lord,
For one reason or the other, the the DPC is not held, the DPC is delayed.
yes, my lord,
By the time the DPC comes, I've committed murder.
my lord,
The DPC will shut its eyes and then say promote.
never, my lord.
Then
These,
Then if it is, we give you an absurd example
yes, my lord,
because situations are best understood with absurd examples.
of course, my lord, of course, my lord.
So if you're not eligible, during that 4 period, under consideration, excellent.
My lord,
No grievance, nothing, excellent. But before you get the promotion, something comes in, will you still get it? That's not in public interest. It would be opposed to public policy. So whatever you argue,
my lord,
unless you can show us Supreme Court has said this, Supreme Court can say that you can fly on water also.
my lord, I do appreciate, my lord, what has fallen for my lord, my lord. Only in case of one judgment, I couldn't actually go through this, but I couldn't actually get a judgment relating to what we are trying to project, my lord. That in case of considering the meaning that has to be given to both the 2 applications, vis-a-vis, my lord, the 1992 and 2010 has to be harmoniously constituted so that the incumbents are not deprived from their dues that they are entitled to, my lord. On the basis of that pretext, my lord, we have basically filed.
And you must also remember, promotion is not a right.
Consideration is a right. my lord.
Consider promotion is a right.
Of
but
course, my lord.
promotion is not a right.
Yes, of course, my lord. Article 16, my lord. And they have rightly considered.
Therefore, they've considered you.
Rightly considered.
But in considering, they've taken a notorious fact into account.
My lord.
A fact which may not have any relevance on the period,
Yes, my lord.
but it is otherwise a notorious fact.
My lord.
That disciplinary proceedings, some kind of departmental proceedings are pending against you. Once you're acquitted, you'll go back to the thing. Have you been acquitted?
Mano, so far the departmental DPC is concerned, I have been discharged by an inquiry committee, but in that regard, the CBI which is holding the inquiry has not been completed, my lord. And there is another matter which came up in 2021. There they have not even started the DPC, or almost a year and a half has gone by now, and no review has been done periodically also.
So have it quashed.
So that aspect,
Quashed.
my lord, that aspect is there, of course, my lord. And insofar as the other part of the CBI inquiry is concerned, they have also filed a charge sheet.
What is the allegation against you?
In the first case, that I have basically alleging that I have basically given some illegal gratification to the complainant. Complainant is also one of the professors in the department.
Gratification.
My lord, giving some kind of allegations are there, my lord, which has been basically, my lord, exonerated by the departmental inquiry committee, my lord, wherein they have said clearly, the inquiry report is here, my lord, that my involvement is not there at all, my lord.
Oh, then why should the CBI continue with that matter?
Exactly, my lord. That now the problem lies with the fact that
Because there is I have enunciated a rule,
my lord,
and it is now by and large followed,
my lord,
that if the act
my lord,
complained of
my lord.
has nexus with your duty,
Yes, my lord.
then the departmental proceedings will have primacy.
Exactly, my lord. Absolutely.
But if it does not have nexus with your duty, it's like you committed robbery on the road,
My lord.
then the criminal action will have primacy.
Absolutely, my lord. Absolutely.
Now over here, since it's an action in
Inside.
connection with your job,
Correct, my lord.
once your DPC, departmental inquiry has cleared you, the CBI should not.
My lord.
Anyway, those are steps that we have to take.
Take later on, my lord, of course, my lord.
But for this proposition,
My lord.
you will not get any authority.
Actually, my lord, and there was another aspect I just wanted to project, my lord. Now, what happens, my lord, under the regulations, my lord, there is another aspect, my lord, just come, where it says like, if, my lord, my case is put in seal cover, there is a mandate again under the UGC that you'll have to review my seal cover, my lord. Now, this review has to be done from the date they put my case into seal cover. Now, almost, my lord, 1 year, 6 months have gone, and periodically for 6 months, they need to review, the university has to review my seal cover. Now, in this case also, they haven't started any reviewing of my seal cover proceeding which is pending, in which case, an ad hoc promotion is basically given. The reason for me to put this before Lordship is that, they are free to give me a ad hoc promotion on the basis of these mandated provisions of the UGC. Now, they are sitting for the outcome of the CBI inquiry and the trial, but they are not doing this part of the aspect, So, can I make a submission, that at them?
So far, my lord, the review part and other things, this has never been raised before the learned single. The learned single judge, the only case is this thing open in the seal cover. That is their prayer. And I have categorically stated in my petition what was the position on the date DPC was held. Clearly, categorically.
Very well.
Lordship.
We'll adjourn the matter. We will not say anything. Let him make a representation for review. You do that. You decide in accordance with law.
My lord, I do not know, my lord, because this aspect I have not gone into. Whether it is
We are also
provided-
not going into it.
Lordship.
We are not going into it.
My lord.
He says he has a right.
My lord, I have the
If he does, he will make an appeal to you.
Of course.
You consider it,
My lord.
because you are not against him.
Bas.
You have exonerated him.
No, my lord, there are two cases.
One
So
case
far,
and-
one case is concerned, my lord, perhaps.
You have
The
exonerated.
other case is concerned, my lord, the matter is still pending.
They have not even started the review, my lord. That was what I was submitting.
You have not started the inquiry.
Inquiry, my lord, there could be the reason, my lord, there are things, my lord, when the trial, my lord, the evidences, my lord, did to say, my lord, perhaps
Not always. Not always.
depend on the situation, your lordship.
But if it is the evidence, if it pertains to his line of duty, then you're going ahead with the matter, because Mr. Sen, in criminal proceedings
Lordship.
that he faces, the prosecution has to discharge the burden of beyond reasonable doubt. In disciplinary proceedings, that's not the case. It may be slightly higher than preponderance of probabilities because of the nature of the punishment that he faces, but it is not beyond reasonable doubt. So you take steps in those proceedings and you punish him. then the promotion goes scotched.
Yes. My lord.
We'll grant him some time.
My lord.
Or Lordship, my lord, since he wants a review, we'll seek a review before the university authorities. So for this matter is concerned, Lordship can close it and direct him, my lord, he can come before the university, and if he is entitled, we'll consider.
Very well, that is also another way.
My lord, it will do, my lord, because ultimately they are the authorities.
We follow.
My lord.
The grievance of the appellant is that despite the appellant's fate as to promotion remaining sealed in an envelope, and the appellant having been discharged from one of the two departmental proceedings instituted against him, and no inquiry having been commenced into the other, the appellant has been denied the promotion that he hopes remains closed in the sealed covers. Paragraph. It is not in dispute that two sets of disciplinary proceedings were initiated against the appellant, who is an associate professor in the biomedical engineering department. That's the department?
Yes, my lord. Biomedical engineering department, my lord.
Of the respondent university. Full stop.
My lord, may I just
What is this?
point out, this is the notification I would
We are
like.
not going into all this.
Okay, I'm obliged. my lord.
In one of the cases, pertaining to illegal gratification, the departmental inquiry has exonerated the appellant. Full stop. However, the appellant says that in the corresponding case, pending, where investigation is being conducted by the Central Bureau of Investigation, no favorable report has no favorable report by the appellant has yet been filed. Paragraph. In respect of the other set of proceedings, the appellant says that despite a period of more than 18 months having elapsed since the memorandum of charges were served on the appellant, no inquiry has yet been initiated. Full stop. Paragraph. The appellant says that there is a procedure under the University Grants Commission rules, and which is applicable to the respondent university, where even during the pendency of disciplinary proceedings, the sealed cover decision is reviewed and may be given effect to on an ad hoc basis, subject to the ultimate outcome of the disciplinary proceedings. Paragraph. On behalf of the respondent university, it is submitted that such aspect of the matter of there being a procedure for reviewing the decision in the sealed cover or giving ad hoc effect thereto, was not urged before the writ court. Full stop. According to the university submits that all that the appellant asserted before the writ court was that since the appellant had been discharged, had been exonerated in the first set of proceedings, and the allegations pertain to a period after the appellant became due to be considered for promotion, the institution of the disciplinary proceedings could not have been taken into account for the purpose of reckoning whether the appellant ought to be promoted. Full stop. Paragraph. It has been rightly held in the judgment and order under review that even though the process for considering the desirability of promoting a candidate should commence upon the candidate or the sets of candidate or the set of candidates becoming eligible for promotion, and the consideration is the performance over the previous period of time, it is also an accepted norm that if the promotion exercise is conducted later or before the time the promotion is granted, any disciplinary proceedings are commenced against a candidate, disciplinary proceedings are commenced against a possible promotee, the promotion is withheld and the decision of the committee in such regard is kept sealed in an envelope. Full stop. Paragraph. Indeed, it would be opposed to public policy if an employee in any government organization or any other organization answering to the description of other authority within the meaning of Article 12 of the Constitution were to be promoted merely on the basis of the consideration of the relevant period without taking into account any notorious fact that may have occurred prior to the decision to promote being implemented. Full stop. In such sense, the judgment and order of the trial court cannot be faulted. Full stop. Paragraph. However, since the appellant says that there is the procedure for the employer reviewing the position, particularly in the light of the appellant being exonerated in the first case and the inquiry in the second case not having commenced, it will be open to the appellant to make an appeal to the respondent university, by citing the appropriate provisions, whereupon the employer will consider the same in accordance with law and communicate a decision to the appellant within 4 weeks of the receipt of the appeal. Full stop. In case the appeal in such regard is rejected, due reasons therefore should be indicated. Paragraph. WA number so and so. Right at the top. In view of the good ground shown, the marginal delay of about 5 days in preparing the appeal is condoned and the appeal is taken up for immediate consideration. Then right at the end, WA so and so is disposed of without interfering with the judgment and order under appeal, but by granting liberty to the appellant as indicated above, then the miscellaneous application is allowed. There will be no orders to cause.
Only please, Your Lordship. Lordship has referred to two sets of cases.
Yes.
First set of cases, my lord, so far the DP is concerned, my lord, exonerated. So far trial is concerned, my lord, is going on.
Yes, we have recorded that, the CBI thing.
And my lord, the other thing, my lord, instead of 4 weeks, if Your Lordship make is 2 months.
No, 4 weeks is more than enough. Reject it.
Because now, right now, my lord, in the peak of the academic session, Your Lordship,
So what this, all things go on together.
you can make it, my lord.
Even peak of monsoon, we say that we will not work. All of them
Make
go
it 6
together.
weeks, my lord.
No.
I'm deeply obliged, my lord.
Thank you.
I'm deeply obliged.
Obliged.
Item number 4.
Yes, madam.
May it please, Your Lordship. Lordship,
Yes.
on behalf of learned DSGI, Lordship, I pray for some accommodation.
On the behalf of,
Learned DSGI.
where has he run away?
Lordship,
He was just here, he ran away.
due to some urgency, Lordship, he had to leave the premise.
No. Not these matters.
Lordship,
Not
if,
these matters.
Lordship, if it
No,
can be taken
not these
up.
matters. We will dismiss the appeals. No, he's just running away from me. No, this is not fair. Please tell him this is not fair. We've expressed our mind. There is no ground. And this is a matter of 2011. Have you seen? It's an appeal of 2011. It's a blog that appears in my computer every day. 12-year-old matter pending. Today is what day of the week?
Today
Thursday.
is Thursday, Your Lordship.
Oh, September is here. 25th. Yes, 26th. 26th. Just give us one or two judgments that we can refer to and
I have submitted my compliance, Your Lordship.
compile.
Compiled, yes, I have
Very good.
submitted, Your Lordship.
Just cite one or two out of that, because we'll finish and dictate the order in court itself. We won't. A further adjournment is sought on behalf of the union. Full stop. Two matters or one matter?
1 minute, Your Lordship.
The matter is peremptorily fixed on September 26. Full stop. No further adjournment should be sought. Yes.
Highly obliged, Lordship.
Deeply obliged, Your Lordship.
Supplementary 1. Item 1.
The matter has been
May I please, Your Lordship?
taken up
May I take Your Lordship to the order?
today in view of the urgency cited. Paragraph, the petitioner will serve the alleged contemnors and inform them that the matter will appear on
Fourth, the other matters are on 4th, my lord, maybe together, my lord. The writ appeals have been ordered to be listed on 4th. So it may kindly be listed.
of October.
Yes, my lord. It may kindly be listed on the day, my lord.
Very well, will appear on October 4th.
Highly obliged, my lord. Lord, can we also take dusty service, my lord? In Manipur, my lord? In addition,
Liberty is given to the petitioner, comma, in addition to the regular service to be attempted by the department, comma, to serve the respondents by any effective mode, comma, including by email, and file an affidavit of service on the returnable date.
obliged, highly obliged. my lord.
From the main list, item number 1.
Yes.
Lordship, I'm praying for a week's time, Lordship, to file our.
What for what? He says that it is a statutory arbitration. 11 is not maintainable. Answer that point.
Lordship, actually, Mr. Paul is leading in this matter.
So, unbehelped.
Lordship, I'm praying in
The
this
virtual mode is available. No.
1 week's time, Lordship. I'm
No,
praying.
no.
Last opportunity may be given.
You've granted enough time. It's not maintainable. He said it twice.
My Lord.
Yes. Where is the arbitration agreement?
This is a statutory arbitration under Disaster Management Act.
Disaster Management Act.
Disaster Management Act.
Yeah,
2005.
But, my Lord, I'm praying if this matter can be taken up tomorrow, my Lord, in that even, my Lord.
Sure. At the request of the petitioner, let the matter stand over for the day.
My Lord. Will you pledge?
Yang botol